If you received a notice recently from your state DMV, whether it was a routine renewal reminder, a request to update your address, or a letter about a past citation you thought was already resolved, stop before you set it aside. That letter may be connected to something larger than a routine DMV matter. In 2024, the federal government expanded the data sharing infrastructure between state motor vehicle databases and the Department of Homeland Security's immigration enforcement systems. The expansion was documented in a federal notice. It was not announced in the national news. It was not sent to drivers as a personal alert. What it means in practice is this. Certain state DMV records, including license status changes, address updates, and unresolved citation flags, are now being cross-referenced more actively against DHS non-citizen records than at any point before. For green card holders, visa holders, DACA recipients, and any non-citizen who drives, this is not a future concern. The system is active now. Immigration attorneys are billing $375 per hour to advise non-citizen clients on exactly what this cross-referencing means for their case. You are getting that same information right now. And there is one connection between your driving record and your green card renewal timeline that almost nobody is covering. And we will get there before this video ends. I am David, and I went through the official DHS infrastructure notices, the USCIS policy manual on good moral character determinations, and the Federal Driver Privacy Protection Act amendments directly. Everything here comes from dhs.gov and ucis.gov, not community forums, not secondhand sources. Before we go through this completely, DHS does not send non-citizen drivers a personal letter when a data sharing expansion goes into effect. They publish a federal notice and they move forward. Subscribe right now and turn on the notification bell so this channel reaches you before a system change affects your status or your case. And join our WhatsApp community linked in the description. We send confirmed updates the moment they are verified. No rumors, no speculation. One message to the right family group tonight could protect someone whose DMV letter is sitting unopened on their kitchen table right now. Now let me show you exactly what we found. Here is what is confirmed under current federal law and USCIS policy. The Driver Privacy Protection Act of 1994, as amended, restricts the general disclosure of personal information from state motor vehicle records. Under that law, private individuals and most commercial entities cannot freely access your DMV file. That protection is real. It applies to all drivers regardless of immigration status. Here is what is circulating in immigrant communities right now on social media and in WhatsApp groups that is not accurate. That any contact between a state DMV and a federal agency automatically triggers an immigration investigation or deportation proceeding against the driver. That is false. A routine DMV data sharing process, including the sharing of license status and address information, does not by itself initiate an immigration enforcement action. But here is what is true and what the viral posts are missing entirely. A specific category of DMV flag, unresolved citation holds, suspended license status, and identity document discrepancies does create a record that DHS can access under the authorized agency exception to the Driver Privacy Protection Act. That specific flag category is what creates a real exposure risk for non-citizen drivers, and most people have no idea whether that flag exists in their record right now. We are going to show you exactly what to look for and exactly what to do. The first thing the official documentation confirms is which specific DMV record categories are accessible to DHS. And they are more limited than the viral posts suggest, but more significant than most drivers realize. Under the Driver Privacy Protection Act, federal agencies, including DHS, have authorized access to motor vehicle records for purposes of law enforcement, including the enforcement of federal statutes. The records accessible under this authorization include license status, whether a license is valid, suspended, revoked, or expired, identity information used to obtain a license, and the existence of outstanding holds or unresolved violations. General driving history, speeding tickets paid in full, minor civil infractions with no outstanding balance, is not in the category that creates active cross-referencing exposure. The category that matters is this: an unresolved license hold. A hold is different from a paid ticket. A hold occurs when a citation has not been addressed, not paid, not contested, not resolved through a court appearance. and the DMV has placed a restriction on the license record as a result. For non-citizen drivers who moved between states, who received citations while traveling, or who had citations sent to an old address and never received them, an unresolved hold may exist in their DMV record right now without their knowledge. Say exactly this when you call your state DMV to check your record status. I would like to verify that my license has no outstanding holds, suspensions, or unresolved citation flags across all states where I have previously held a license. Nothing more. That specific request prompts the DMV agent to check the full record, not just the current state file. Never assume that because your current state license is valid, there are no holds in another state. Under the Non-Resident Violator Compact, which most states participate in, an unresolved citation from a prior state can trigger a hold that appears in DHS cross-referencing even when your current state license shows as valid. This exposure risk applies to all non-citizens who hold or have held a U.S. driver's license, green card holders, H-1B workers, F-1 graduates, TN visa holders, DACA recipients, and individuals on any type of work or residency authorization. It does not apply to U.S. citizens, for whom the consequences of an unresolved hold are limited to DMV penalties and do not carry immigration implications. Immigration attorneys charge $350 to $400 per hour to conduct exactly this kind of pre-renewal DMV record audit for non-citizen clients. This is that audit. But the second point is where most non-citizen drivers have been given wrong information. And it involves what happens when a license is suspended and a non-citizen continues to drive. The second point involves the legal classification of driving on a suspended license, and why it is not treated the same as a traffic violation. Per USCIS Policy Manual, Volume 12, Part F, Chapter 5, good moral character determinations for green card renewals and naturalization applications require USCIS to review whether the applicant has been convicted of any crime. Driving on a suspended license is classified as a misdemeanor in most U.S. states, not a civil infraction, not a moving violation, but a criminal offense. Under INA Section 101A 48, a conviction for immigration purposes includes any case where a judge or court accepted a guilty plea or a no contest plea, regardless of whether jail time was imposed. A plea of guilty or no contest to driving on a suspended license, even when the penalty was only a fine, is a criminal conviction for USCIS purposes. Consider a green card holder who received a citation for an expired registration and did not respond to the notice because it was mailed to an old address. The DMV suspended the license for non-payment. The person, unaware of the suspension, continued driving normally. 6 months later, a routine traffic stop revealed the suspended status. The officer issued a criminal citation for driving on a suspended license. The driver paid the fine and considered the matter closed. 2 years later, at a green card renewal interview, USCIS flagged the misdemeanor conviction under the good moral character review. The renewal was not denied, but an additional 3 months of processing was required to document the circumstances. The correct step would have been to check DMV record status after any address change and before assuming license validity. Third, and this connects directly to the new system mentioned in this video's title. The third point involves the specific mechanism of the expanded cross-referencing system and what triggers an active flag, versus what stays in the background. The expansion documented in federal infrastructure notices covers the frequency and scope of automated matching between state DMV databases and DHS non-citizen records. Under the prior system, cross-referencing occurred primarily at fixed points: license issuance, renewal, and formal law enforcement encounters. Under the expanded system, certain DMV status changes, specifically license suspension, identity hold, and address change in combination with an open citation, trigger an automated query against DHS records at the time the status change is entered into the state database. What this means practically is that a non-citizen driver whose license is suspended for any reason, including an unpaid parking ticket that escalated to a hold, may now generate a DHS query automatically, without any traffic stop, without any law enforcement encounter, and without any notification to the driver that the query occurred. The driver never receives a letter saying a query was run. The query happens in the background. If it results in a match with an open immigration matter, an expired visa, an unresolved status change, a pending removal case, the match is logged and can appear in an immigration case review. Most non-citizen drivers have no idea this process is occurring. And fourth, this is the specific detail that most coverage never reaches. The address registered with your state DMV is a data point in the expanded cross-referencing system. A DMV address that differs from the address on file with USCIS is a discrepancy that appears in both databases simultaneously. For non-citizens who are required to notify USCIS of address changes within 10 days under INA Section 265, which applies to all non-citizens except those in certain status categories, a DMV address update that is not matched by a USCIS AR11 address change notification creates a documented inconsistency. That inconsistency is visible in the cross-referenced record and can generate a flag during a renewal review. Updating your address with DMV and failing to update it with USCIS or updating USCIS and not DMV creates the same discrepancy in opposite directions. Both are avoidable with one additional step. Now here is the connection that almost no coverage reaches. And this is what I mentioned at the beginning. Your driving record does not just affect your license. It connects directly to your green card renewal outcome, because USCIS now has access to a more current and more complete picture of your DMV history than at any point in the past. Here is the mechanism in plain terms. Under the expanded data sharing framework, USCIS adjudicators reviewing green card renewal applications can now query a more current snapshot of a non-citizen applicant's DMV record at the time of adjudication, not just the record as it existed at the time the application was filed. This means that a license suspension that occurs after an I-90 renewal application is submitted, but before the application is adjudicated, can appear in the record the adjudicator reviews. In real terms, for someone in your situation, a DMV hold created by an unpaid citation, something that would have been invisible to a USCIS adjudicator under the prior system, may now be visible during the adjudication window. A hold that generates a misdemeanor charge while the renewal is pending can delay or complicate the renewal that you thought was already in process. Keeping your driving record clean during an active USCIS application period is not just about avoiding traffic problems. It is now directly connected to the outcome of your immigration case. Most families never find out about this connection until an adjudication delay arrives with no explanation. Here is your exact plan. Write this down or save this video. Step 1. Contact your state DMV, either online or by phone, and request a copy of your full driving record, including any holds, suspensions, or unresolved citation flags. If you have lived in more than one state, request records from each state where you held a license. Do this before your next USCIS application or renewal. Step 2. Go to USCIS.gov and confirm that the address on file with USCIS matches the address currently registered with your state DMV. If they do not match, file Form AR11, the change of address form, at uscis.gov R11 immediately. It is free and takes less than 5 minutes. Step 3. If your DMV record shows any unresolved hold or citation flag, contact the court or agency that issued the original citation and resolve it before filing any USCIS application. Do not file a renewal while a DMV hold is open. Step 4. If you are stopped by law enforcement and the officer indicates your license has a hold you were not aware of, say exactly this: I was not aware of any hold on my license. I would like to understand what the hold is for. Do not add anything else. Do not explain your immigration status. Do not attempt to resolve the hold at the traffic stop. Step 5. Share this video with one non-citizen driver in your family or community right now. The address discrepancy issue alone, DMV versus USCIS records, affects thousands of families who updated one and not the other. Send it directly to their phone tonight. Official resources: USCIS address change, AR11, USCIS.gov, AR11, USCIS, USCIS.gov, 1-800-375-5283, DHS, DHS.gov, Immigration, Legal Aid, ImmigrationAdvocates.org, Free Immigration Help, NILS.org, ACLU, Know Your Rights, ACLU.org, Know Your Rights. 2 warnings before we finish. First, immigration scams. There are people charging non-citizen drivers to clear DMV holds from immigration records or to file special notices with DHS on the driver's behalf. These services do not exist as legitimate offerings. No private consultant can remove a DMV record from DHS cross-referencing. No one outside USCIS can modify what an adjudicator sees in your file. Only work with attorneys licensed by a state bar or BIA-accredited representatives. Verify any representative at justice.gov before paying a single dollar. Second, benefit scams. If anyone contacts your family member by phone claiming that their social security number or green card has been flagged because of a driving record issue and that they must pay to clear the flag, that is a scam. DHS and SSA do not notify people of record flags by phone. Real federal agency communication comes by mail only. Hang up immediately and call 1-800-772-113 to verify anything SSA related. I want to hear from you directly. Which country are you originally from? And have you or someone you know received an unexpected DMV notice or a license hold that created a larger problem than expected? Drop it in the comments below. I read every single one, and your questions shape the next video. What we covered today is documented, confirmed, and already operating in the background for non-citizen drivers across this country. DHS will not send you a personal letter when a data sharing expansion changes what is visible in your record. This channel will. Subscribe, turn on notifications, and join the WhatsApp community in the description so urgent updates reach you directly. I am David. You have rights in this country. You have benefits you have earned. Knowing both protects everything. Take care of yourself.